Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I want to talk about restraining orders. As you may know, in the context of a divorce case, the court can order, like it can in any case, an order restraining someone from doing a certain thing. It could be restraining someone from acting in a certain way. It could be an order restraining someone from harassing someone. It could be restraining someone from selling off a piece of marital property or an asset. So it could be financial restraining order. There's all sorts of things it could be. The point of the restraining order is that the court orders someone to be restrained from doing a certain thing. So therefore, the question comes up, well, what if he does it anyway? In other words, let's say a person's ordered to not, spend any money on some big ticket item, and you find out they went and they bought a boat or whatever. Or let's say a person is restrained from coming to the marital home, and the court learns that, she's there. What happens? And what are you supposed to do? Well, number one, you should call your lawyer, because there should be a discussion between you and your lawyer as to whether or not it makes sense to bring it to the court's attention. That is to say, is it enough of a violation of the order to justify the time and expense of filing a motion to ask the court to hold the person in contempt for violating that order? If the court, for example, has restrained somebody from coming to the house before 6 p.m. and somebody shows up at 5:58, yes, it violated the order. The question is it something to bring before the judge? Or are you just going to be in a situation where the person's going to say, well, Judge, my watch said 6 o'clock. I don't know what to tell you. Is it something that the court's going to take seriously, or is it something the court's going to look at you and say, why are you bothering me with this nonsense? Because in every order, there's the order and there's the spirit of the order, and the spirit cuts both ways. The spirit cuts to compliance. Are you complying with the spirit of the order? And the spirit cuts in the way of enforcement. Is this enforcement within the spirit of what I intended when I made that order? And so would the judge analyze. So you got to think about that. Number one, is it the kind of thing to even discuss? And number two, in order to do that, you got to look at the history. What's the history been? Is it a situation where the person has violated in the past? Because if it is a situation of repeated violations, even a small violation is just part of a pattern and practice. You see, if it's the first time and it's a small thing, you might say, well, I don't know if we should go forward with this. It's going to cost me, $1,500 to have a hearing on this, and for what? But on the other hand, if there's a pattern and practice violation, you need to bring it to the court's attention, even if it's small. And so there's a spectrum. On the one hand, if there's a lot of violation, even a small amount should be brought to the judge hand. If there's no history of violation, perhaps even a larger violation, you should at least think about whether or not you should bring it to the court's attention. Many times you should be aware that when motions for, let's say, change of custody are filed, they are bolstered and supported by the fact that there have been repeated violations of prior court orders, and therefore, what makes the court think that this person will violate the custody order? So in that kind of situation, sometimes it makes sense to bring things to the court's attention, even if you think the court's not going to react all that well to it, or the court's not going to take enforcement action on it, so that you can build a case for violations later on. And I will tell you, here at the firm, many times when we'll have a case where we'll want some big relief, we'll be able to come to court and say, look, this person has a history of 7 violations. We've been before the court 7 times. And in each of those times, Your Honor, you have said, you better not do it again. You better not do it again. You've given them chance after chance after chance. It's enough already. We want the custody change. We want something dramatic done. And a lot of times, those things will support a dramatic result. So you got to keep that in mind. If you have any questions about your case, reach out. We'll be glad to help you out.